Wayne Stacy. I'm from University of California, Berkeley School of Law. I lead the Center for Law and Technology there, which oversees everything. Oversees a big word when you've got 22 professors. No one oversees professors, you know that. But everything is from patent to AI. So we see this kind of cross-section of the world. My background is not academic. This is the twilight of my career, my second job after I retired. I spent 25 years doing patent litigation, mostly high tech. With that, now that I'm clear of that and I don't have clients, I don't have to have a dog in the fight anymore, and can kind of offer some unbiased looks at what I think is going wrong with the system. So what I want to do is I want to start with throwing out two controversial statements. One's probably not. The other one, if I'm not being recorded, it's better off. I'm going to let you as I give it to you. So the first part I want to talk about is, there's an old Seinfeld episode that says there's two parts to the reservation. You're taking the reservation and keeping the reservation. And when you look at the IP system, people tend to talk about one part or the other, but there are two parts. You've got the procurement system. That's the patent office's job, the copyright office, and then you've got the enforcement system. That's what's going into the courts. And those two systems need to be evaluated separately. And so that's what I want to talk about here and look at this compare and contrast between two systems. The trademark system, which seems to be pretty effective and pretty economical in the grand scheme of US IP. And then the patent system, which I will argue has been spiraling downward for probably 15 years and maybe beginning to accelerate its downward spiral because of pressure from the European Union and some other large countries that are running IP systems effectively. So one system looks like it's working, the other one looks like it's broken, maybe broken so severely we can't recover in the next generation. So with that, now you know why I didn't want to be recorded. So I wanted to start with a trademark. Diane has more trademark knowledge than anybody I know in terms of how it works, but also how it makes companies more powerful. So you start with you, Diane, on why the trademark system works, or
Wow, okay. So I'm Diane Gabl Kratz. I'm Director of IP Strategy and Operations at Dolby Laboratories, headquartered in San Francisco. We had the pleasure of hosting this event last year in San Francisco. It was a great opportunity to come together with thought leaders from so many different backgrounds. So I am a registered patent attorney, but I'm also head of trademarks at Dolby. And I also head our IP operations team. So I manage an 18-person global team. I'm not sure I would say that our trademark system is super strong. I think overall, it certainly has more certainty than our patent system does, and that's quite a relief for many of us. But enforcement is really where things start to unwind. So for many of you, those of you who are at operating companies, or even just if you're just a consumer, you realize the threat of counterfeits and how challenging it can be when you're trying to purchase something on Amazon or on Alibaba to make sure that you are actually getting a genuine good. Now, this kind of issue is a little bit less relevant for Dolby, given our business model, which I can talk about later, but it really does reveal one of the greatest weaknesses in our trademark regime now, which is that it is so difficult to combat counterfeits. Back in the day, before the internet, before online commerce, it was much easier in some ways to actually deal with these things. You could have a team go to an open air market, identify counterfeit goods, and basically get it shut down in many different countries. Now, of course, we are against a very, very different landscape online. And for so many companies, especially companies in the luxury goods and the kind of the clothing, brands, fragrances, are running into all sorts of problems with counterfeits. So that's kind of a big, broad comment on some of the weaknesses of the trademark system, but particularly in terms of enforcement.
Thank you for those comments, Diane and Wayne. I'm James Conley. I've been to every one of these IPAS events. Bruce has been kind enough to invite me, and we've hosted them like Dolby did last year. We hosted them at the Kellogg School of Management together with my colleague who spoke earlier, Dan Brown. I'm a nuclear engineer who became a material scientist and designed automotive engines, glorious internal combustion engines, in the days when those were really super. And I have my hands all over the design of Subaru horizontally opposed engines. I spent 8 years in Japan doing this. Somehow, I became one of these difficult people that Wayne has to manage, a university professor, accountable to nobody. And this means that my mind could wander. And it could wander to all of these places that I'd been during my career as an engineer, including inventions that we'd made, patents, which eventually, became commercialized independent of my prior employer. And my joint inventor, Jerome Lemelson, and I took these to all sorts of interesting places, which is, subject of another discussion. But since that time, which was the early 90s, I've been at Northwestern, developing this whole idea of, yes, property is an important source of competitive advantage, but we have to look at it holistically. In the title of this panel, we had 3 different kinds of property. And indeed, my colleagues at the law school become distinguished professors specializing in each of those kinds of property. And the law evolves particularly in each of those areas of property. But as managers and entrepreneurs, the real opportunity is to look at it all together and figure out how to use what, when, where, and how. And we heard a little bit of that from Tiffany earlier. This difficulty that we're experiencing with patents is not something new. I mean, we wrote extensively about this after the eBay versus MercExchange ruling that canceled the ability to get, a unilateral injunction. Interestingly, in Europe, you can still do this. And in other places of the world, you can do it. And a lot of litigation is moving there. But I think the patent system has been substantially weakened relative to when I was really using it aggressively with my former inventor for all sorts of reasons. But there's ways to resurrect it. And if you think more broadly about the way that my colleague Diane here, Dolby has used it over the years. There's so many lessons in that. I spoke about some of that last year. I bet Albie is the only one here in the room that actually remembers Dolby's original trademark, right? You can see it on the screen back there. It's got these 2 things facing each other. If I polled the room, nobody would be able to tell me what those 2 things are, right? But Albie knows, right? And it's because no one has even seen this technology. Those are old magnetic heads. The originally Dolby mark had a line through the middle. That was the tape. Do you remember, Albie? And somehow the sign has evolved, right? There's no more tape. The line's gone. And in fact, the whole system around Dolby is very cleverly evolving with time, but it's doing it through the mark. The mark is aggregating all the goodwill. So yes, while there are these weaknesses, Wayne, in various appropriability regimes and domains, I see them as an opportunity. As we go through this discussion, I'll talk about other opportunities.
And I should say I'm very grateful to James for pointing that out to me because I didn't know that at all. No, trademark attorney, and I've been at Dolby a little bit over 5 years. So I should also add I am not authorized to speak on behalf of my company. My opinions are my own before I accidentally say the wrong thing.
So I think that is an interesting discussion, and that 2006 was the mark when all U.S. patent law really changed around injunctions for the enforcement side. And we often want to talk about what the United States Patent and Trademark Office is doing. It's just an executive agency. It basically can do nothing other than regulate itself. And anything that they push out in rules can be changed in the next few years, which is what's happened recently. You start cycling through these rules every 4 years, but a patent is supposed to be a 20-year business strategy. It's supposed to be something that's long-term. And actually, I think the average lifespan for a USPTO director, I guess lifespan is a little morbid, their average time at the patent office is less than 3 years. So, and if you're changing administrations, you're changing theories. So the patent office is not a mechanism for long-term change. Only Congress is going forward. And I would argue that we're probably 10 years away from any meaningful change on the patent side. Trademark does get a lot more attention these days because of because of anti-counterfeiting, it's easy to grasp and articulate, it seems. So you'd mentioned problems like online, like Amazon having trouble, but there have been all of these remedies. How do these kind of economical remedies popping up match a general IP world?
Economical remedies.
Well,
damages kind of.
Amazon's got its own enforcement strategy.
Yes.
You have ability to seize pirated goods at the border, or shut something down in an open air market, or confiscate somebody's van in New York City that's selling purses out the back. Those are pretty easy to spot these days. So compare that to a patent litigation, which runs cheap, $8 million a side these days.
That's true. So I think on a case-by-case basis, any one-off kind of enforcement action on a trademark side is often, it's going to be a lot less expensive than patent litigation. And again, there's, I'd say, a real movement away from the brick and mortar kind of enforcement, more to the digital enforcement. And platforms like Amazon, of course, do have their own internal mechanisms for takedowns, but these are very, very challenging systems to use. They are unreliable. Often something gets taken down and it just pops up over here under a different account name. It's the same with spam, right? You can block every single weird spam email you get, but you're going to be getting thousands more just under new, 15 letter long email addresses. So it's a good thing that they have it, but I would say it's far from sufficient, and it really is an impossible situation for a lot of companies. It's the typical whack-a-mole problem is how they usually describe it. James, I don't know if you have some comments on.
Well, every time I hear an explanation of, the cost and the litigation costs going into the calculus of whether or not we're going to do something, I have to go upstairs to the finance department and remind them that there's goodwill, and all these numbers that are running around aren't capturing that. And so I try to use examples of how people are operating, doing the calculus of the cost of counterfeits and all of the rest. And I find them episodically. One person that we got to invite next year, Bruce, is Hadia Claxton from Tabasco, right? She works for McElhenney, right? And she's a fascinating lawyer. She has the same job that Diane has at this world famous hot sauce manufacturer. No one has ever been to their location. It's in the middle of the Louisiana bayou, essentially, on a salt dome. But, when you hear her talk about infringement litigation and everything, she says, that's really a last resort for us. Every time we see that, we think, what they're doing using the Tabasco brand. She has this great example. A California marijuana vendor, right, wanted to call their brand Tabascush, right, with all the, the green and the red and the whole thing, And, before, you send the cease and desist, they actually thought, what would Tabasco spiced dope taste like? And to actually have that kind of open mind, it takes you in all sorts of different directions. And I'm trying to bring that perspective to management, right? Don't immediately do the calculus of all the, in the last moment, yes, you have to do that. But there's an opportunity here somewhere. And it may be in between all of these appropriability regimes, right? So that's where I am.
So I love the concept that, and this is what I try to teach students, that IP is not a business strategy, at least not at the front end. I have never once come across an inventor or a company founder that came in and said, hey, I want a patent so I can sue people. I like lawyers, let's give them more of our money. Or I want a trademark because I'm expecting somebody to violate it and I want to sue them. There's support for a business strategy, for doing something with your innovation, for getting products to market. How do you, James, we'll start with you. How do you approach that from kind of getting that message out and getting people to stop thinking about IP as the lead and rather looking at the business strategy as the lead? And if you do your business well, maybe you never need to enforce your IP.
Well, I like your description, actually. Right, and we heard some of this in the earlier panels. IP is it's like infrastructure. It supports whether or not, to use the words that Dan shared earlier, you really have some kind of competitive advantage in a marketplace. So the first thing I ask them, and Dan does this too, are you really solving a problem that someone's going to pay for? Forget about the IP. Have you actually solved and created a business case that is compelling in a way that satisfies the need and brings a benefit to the person who you think is going to be your customer? This is exceptionally difficult with university professors who are commercializing their technology. And my friend from the University of Kentucky, he's probably got gray hairs or maybe lost a few hairs having those conversations. I know I lose them every year when I do this. Some folks are able to conceptualize that, a customer and who's going to pay, and others are not. Once we have that identified, then we can write the IP. Because the IP at its very core, it brings a benefit, and patents are about enabling benefits and creating language around unique benefits. And then there's all the marketing, right? That's the story which tells the benefit to the target consumer. And then there's the brand on the outer label, like the electron cloud. This is where all the chemistry takes place. This drives repeat purchase and all that. So I try to use that marketing language to bring them into IP. Okay, what is exactly the technical benefit? Well, how are we going to tell the message? What's the message? And then how are we going to remind them where to get it? And that wraps up patents, secrets, copyrights, and brands.
So Diane, I just want to remind people of one thing. You're now at Dolby, but you're a creature of Silicon Valley. You've been around and seen many different companies. And so I would love your feedback on where patents, trademarks fit in kind of broadly into the Silicon Valley ecosphere.
I love how broad that question is too. So a little bit more background is I started my career in big law at Morrison Foerster, later at Sidley Austin, primarily doing patent litigation, but also other kinds of IP litigation. So for example, I worked on the Oracle Google case, for those of you who may have heard of that one back in the day. After that, I went in-house, and my first company was Seagate Technology, which is a Fortune 500 hardware company. And Seagate had a dramatically different IP strategy than, say, Dolby Laboratories does. So I'd love to contrast the two because I think it's reveals some very interesting things. So back at the time when I was at Seagate, Seagate had one primary competitor called Western Digital, WD. And Seagate and WD together had well over 75% of the market for hard drives. So basically what you had was a duopoly. This kind of Cold War thing going on between Seagate and WD. And both Seagate and our competitor had built up these really large patent portfolios. And not just patenting really clever, brilliant innovations that were going to add so much value to the marketplace. No. Patenting slight incremental improvements just to keep building up that pile of patents, right? So it really was this strange kind of situation. And at some point, both companies had these massive patent portfolios that were paying annuities on, over the years, expending a tremendous amount of money, but for what real value? As a matter of fact, the greatest conflict between Seagate and WD in about that 10-year period was a trade secret misappropriation case that went down in state court in Minnesota and ended in an $800 million judgment. So a very powerful engineer had left one company, actually had left Seagate and gone to WD, and we ended up prevailing on that case. So here we had all this expenditures on building patent portfolios, when at the end of the day, if either party sued the other, it was probably going to be mutually assured destruction. And the more powerful technique in the end ended up being a trade secret case.
So now I want to take what you just said and let's divide the world up into what the innovator's world really looks like. There are really two groups. You got the small and medium-sized companies, and then you've got these giants. And for small and medium-sized companies, and again, I am pro IP. I spent my life in this area, but I've also seen what's happening. So I was called out at another conference for saying that for small and medium-sized companies, those are, maybe a company as big as $20, $30 million, that U.S. patents are fool's gold. They're pretty. They look good on a wall. They give you a false sense of security until somebody actually tests them. And then you've got real problems if you've ever incorporated them into your strategy. And you compare that to these two giants that own the disk drive market. Now, when you ask this question, are US patents, and I'm emphasizing US because I have some different views on the rest of the world, are US patents useful for small, medium-sized companies trying to protect themselves from the giants, from maybe some predatory giants people would point to? And James, I'm going to give you that loaded question.
Everyone wants to give me the mic on that one. Okay. I think they're challenged, clearly, which is the premise of this panel. You know, right now the patent system isn't probably working as well as it could, but it is a living creature. It evolves. Maybe we'll even get a new form of a patent. I think Tony was speaking about what we used to call a utility model. But I think these are essentially important for small to medium-sized enterprises. We just have to be very sure about how and why we're going after them. It should not be a helter-skelter chase for patents simply for the purpose of having patents. We've already heard that the task of doing all the research to make sure that you got new, useful, non-obvious, and all the requirements is being made a lot easier. That should bring the legal costs down. So the legal burden is, or rather the cost burden is coming down on the prosecution side, right? So that's, I think, hopefully going to be good for small to medium-sized enterprises. But what you haven't addressed, Wayne, right, which is critically important for the system overall, is more of a social benefit of the disclosure. The fact that patents are filed is a public disclosure of knowledge. And I think the first time ChatGPT came out, fully 3% of its training set was, U.S. patents. The full set of U.S. patents is what trained ChatGPT initially. So there's that benefit that doesn't necessarily become something that's proprietary. You can try and protect your own goods, but the fact that you've disclosed certainly elevates everyone else's knowledge of your industry and your particular competitive advantage. But around that, now you have to wrap all the quality control information that would be a trade secret, which aggregates to the Dolby brand, right? You have to think more broadly in all of these ways, not just patents. So yeah, I think patents alone is not nearly as attractive as it used to be. But when you open the aperture and actually think about all these possibilities, think a little bit like Hadia Claxton, that infringement might be an opportunity for us all the time. Then I think you can maneuver cleverly.
So I'm going to contrast the earlier example I gave of Seagate Technology with Dolby, a company that is a little bit over $1 billion a year in revenue. We're not a huge company. We're not a small company. We're public. We've been around about 60 years, and there are around 2,500 employees at Dolby. So patents are unusually important for Dolby because of our licensing model. We license patents, standards essential patents for audio and video compression technologies, largely through patent pools, but also through bilateral arrangements as well. And this generates hundreds of millions of dollars of revenue for us. And so intellectual property is embedded deeply within the business strategy. And that, I think, makes it a wonderful place to practice law as an IP attorney like I am. And it also indicates the importance of the legal department to the company. Because unlike most in-house roles, where you're basically a cost center, at Dolby, we are actually helping to generate the revenue. And so for Dolby specifically, patents, even US patents, continue to be extremely important and extremely valuable. But I do understand why you raised that point, Wayne, in terms of some of the challenges that we've seen. And where we're a much smaller company or a solo inventor, that's where you have to start looking much more critically at the value of patenting. And that's where provisionals are still a good option for saving money and for testing something out to see whether or not you really want to take that additional step and file for the full non-provisional utility application.
So I want to share a number. Many of you may have not seen this before, but the percentage of patent cases in the United States now that actually involve two operating companies. And separate out the pharmaceutical world, separate out the medical device world. They run in their own specific area. But when you look at the rest of U.S. patent litigation, over 90% of it is brought by non-practicing entities. And this is not a pejorative discussion about that kind of company, because a lot of times they've been preyed upon and there's nothing left by the time they can get there. Or they might have started as an operating company, but 5 years later, after paying $1.5 million, $2 million a year in legal fees, now they're just borrowing money from different people to figure out how to run the litigation. So what does it say about the US system that it's no longer a competitor to competitor model where people are trying to at scale, or trying to push their business model, trying to protect their business? Patents are being sold off, licensed off, loaned off for just pure revenue. How does that weigh into generating jobs, generating new businesses, and the long-term effectiveness of the US innovation economy?
So my first impulse in terms of answering that question is, at the end of the day, it doesn't matter to me personally so much whether it is an operating company or an NPE filing the lawsuit. I think at root, the biggest problem is frivolous litigation. Are you filing abusively? Is there really anything there? And that's maybe a whole separate question, but I'm much more concerned about that than the exact nature of the entity that is doing the filing. If they have a genuine claim, then under our Constitution, under the way our entire patent system has been set up, they have every right to go ahead and file a lawsuit.
And I don't mean to imply that they don't. I'm concerned, have we priced operating companies out of the patent market? Can they no longer defend themselves against others because it costs millions and millions of dollars a year? I should ask, anybody know what the going rate for a single senior level patent litigator is these days per hour? What, Albie, what was 1,000? 1,000 will buy you a second year attorney out of law school. I heard 1,500, that is about a fourth year. Somebody with my vintage, my gray hair, roughly 2,200 to 2,400 an hour. And I'm not the one that'll hurt you. It's the 8 people at $1,200 an hour that work with me. So I did a little poll among several firms, roughly $8 million total for one side to litigate a case worth $20 million. $8 million invested for a $20 million return. That's insane.
I agree, this is definitely a problem. This is far from ideal, and I particularly worry about the smaller companies and solo inventors. I do wonder what the role of third-party litigation funders could be in helping slightly alleviate that, but I'm sure it would not be sufficient.
Wayne, really glad that you brought up that 90% number.
I thought you would.
You know my background. Okay. So it turns out that that number is an artifact of change in civil procedure, right? When there were long ago lawsuits where a particular NPE would sue, 50 firms, and there would be one lawsuit. But then there was a change in procedure, and they had to have 50 individual lawsuits. Okay, so that number is an artifact of the court, and it isn't necessarily a reflection. Certainly in the number of lawsuits, it's absolute, and the number is there. But there was a change that brought that about. There was, as a actor, there were many more companies that would show up in the numbers that were suing other companies. Okay, and I'm also, like you, very concerned about the small entities. But I think we'll hopefully get some changes. I know that when Dan was on the PPAC, he initiated a whole bunch of different changes from inside the patent office
that were probably promptly flipped by
well,
the next administration.
I think he got put on the slow burner stage, but then when the new administration came in, all of a sudden they looked front and center. Right? And it's pretty much exactly what he suggested needed to happen as a litigator.
I have a question. So why don't more operating companies, and we have Manny Schechter here, ex-IBM Chief Patent Counsel. Maybe he wants to weigh in on this. But why don't more operating companies enforce their patents against other operating companies or other entities? And if NPEs are active, they're active because patents are available. Good patents are made available to them for purchase by operating companies. So it's sort of a conundrum The operating companies don't want to enforce themselves, apparently, for bad publicity or because there's not enough for return, but they'll allow other people and other entities to enforce for them. What's your thinking about that?
Want me to start? I
Yeah.
think the Mannies of the world are too busy making money to, get caught up in IBM in particular. They're in the business to make money and to return to their shareholders. So, patent litigation, maybe at some point if something's really going wrong, but, if you keep your focus on your operations and earning income, the patent thing becomes a bit of a peripheral activity. It's not front and center every day. It's a fallback. You buy the option in the right and you only act on it when you need it.
Manny, do you want to weigh in? No. Okay.
Yeah, so I think those were good points that James made. And of course, the sheer distraction from your day-to-day business, that it's not just the cost of the litigation, it's the cost to your employees, to all the depositions and all of the documents and figuring it out. It's extremely time-consuming, extreme investment, both in terms of time and money. So I think unless you are very confident that you have a strong case, there'd be many reasons not to go down that road.
But doesn't that enable NPEs? Doesn't that give NPEs the opportunity to act? Because the big operating company X is saying, well, we can't do this. We can't afford it. We don't want the distraction. We don't want the bad publicity. We'll just sell these patents to either a broker or directly to an NPE.
Well, I mean, certainly that's an option. Of course, you have organizations like the License on Transfer Network, like LOT, to try to mitigate those sorts of scenarios.
And keep in mind, sometimes those big companies are cleaving off huge portfolios that they're not in the business of anymore. They're no longer operating in that space, so they're taking an asset and moving it off. And good patents, but they just don't need them anymore.
And what about the threat of litigation as a way to force a settlement? So you want to get a license for X number of dollars, and so you begin a litigation, and it's cheaper for them to settle than to fight you in court.
So there are two types of NPEs. There's one group that I think are horrible because they're settling against the litigation cost. They're not the value of the IP. That's a separate group. Congress and people have been trying to address. I call them slip and fall trolls. But there's this other group it's a legitimate group buying valuable patents, trying to settle them for the value of the innovation. And those are real organizations, real financing, in their real assets. And I hate to see those two ever mixed together because they're different group. One group is abusing the system. The other group's just using an asset as an asset.
Yeah.
Right, but the same sort of result.
Actions on both sides, right? You can have parties who know that they are infringing a patent or know that they really ought to be taking a license, and they're counting on the patent holder not to enforce because of the sheer cost and the hassle. And so there's you have to see that kind of activity, that kind of abusive practice can happen on either side.
What I don't like about this conversation is we, who are really very far up the learning curve on IP, fall into the trap of using the broad terms of a narrative that is operating against us. And, universities are NPEs. All we do is generate knowledge, and then we hope someone will take a license to it. Now, we're not aggressively using the settle thing. That requires a different name.
Yes.
But I don't like these broad terms. And I think as we develop explanations and narratives to really refine the role of IP in this age when AI is coming through and changing everything, we should be very careful about it and intentionally be careful. That's what I try to do with my students so that we can actually focus our efforts where we can make headway.
So you can tell this is a touchy topic, and I'm a pro IP person. So James may not believe me after this discussion.
No worries.
I've heard it. So no, they're a very, very different group, and I've represented all sides. I used to be a trial counsel for Acacia, so I've been on all sides of it. but we talk about what's coming forward, and we know that the U.S. IP system is, or at least the patent piece, doesn't run as efficiently as the trademark piece. And the trademark piece has trouble, but at least people are focusing on it and they're trying. There were just hearings last week on counterfeits, looking at drug counterfeits on top of traditional luxury good counterfeits. But what's the future for legislative change in the patent world if there are these problems with the system? What can we look forward to in the next 5 years, 10 years? Or what should we be asking for? And I'd love to hear it from the business side. The lawyers are the ones that screwed this up.
I wouldn't say the lawyers screwed this up. This is just something that's been evolving. Now, it's instructive to read the 2011 White House report that was written as a justification for all of the changes that came through the Patent Office under the American Invents Act. It's really instructive to read that report. Why? Well, they quote a terrible problem in America that is coming from a judge that speaks about an unscrupulous attorney getting a patent from someone who's unsuspecting and then going and enforcing it without any return to the original inventor. The problem with the quote, and no one who wrote the report apparently understood this, that it's from the year 1874. Wow, America really slowed down from 1874 to 2011. This problem is around and the market works, and it's one that we have to continually struggle with. But I don't think the existence of the problem itself is some sign of deteriorating health. On the margins, not having an injunction, that's a problem. That should be available to everyone, small, large. But anyway, that's all I'm going to say on that.
I will say that IP being one of the rare areas where you can often get bipartisan support, I think starting from that presumption, there is a little bit more hope than I would have seen perhaps a year or two ago. I know that there are quite a few bills are in process right now. I don't recall all of the details, so I'm not quite positioned to talk about them. But I don't know, 5 years out, maybe not, 10 years out, I don't think we can really continue as we are. I would expect there's going to have to be some more significant legislative change.
So one of the things that's concerning to me, and I've had conversations with people on the Hill, is that there are only a handful of people in Congress that care about IP, and most of them are retiring at the end of this year. So the question is, who's going to be the next champion? And we've had people that were, I think, probably as close to champion of small and medium enterprises as that you're going to find up there, but they've all decided to retire. So I worry that the pieces that we need to put in place, these bills that are fairly interesting, if they don't have a champion, they're going to die in a committee somewhere. And, because a few of them are para, are on their third iteration, and with powerful senators behind them that aren't going to be there, February next year.
Okay, well, to be oddly Pollyanna-ish or oddly positive, I would say trust the next generation. I think the next generation of legislators, there are going to be people who will appreciate intellectual property. I think even just the rise of AI is increasing awareness more generally. So my hope is that as people become savvier and savvier, we can expect that to be reflected in our elected officials, and hopefully that would lead to change. But I don't have a particular name or particular person I can suggest.
That, I bring up these problems in class, all that you've mentioned and more. They're challenges, but I make it very clear they're not mine, they're yours. You've got to make the system work, right? And that actually is empowering to the students, right? When they see that the system itself is something that they can play a role in some way, not just to benefit from ownership, but to shape it, to make the ecosystems work better. They really like that.
Well, and Berkeley's an interesting institution. It's deeply scientific, and I think it's once again like the #1 institution in the world for undergrads building startups, and it's 9 out of 10 years being in the top 5 for unicorns. these are the kind of small companies that are coming out that I worry about won't have the necessary IP protection going forward. Again, universities should be spinning out knowledge and then spinning out companies to put that knowledge into public use. From the business perspective, what would you be telling those students about the next 5 years to get your company up and running or sold off, whatever the exit event needs to be?
So everything depends on context. That's the first point that we make. Okay, so if you're in pharmaceuticals, the context is this, and the regulars. So we really need to understand the context. And I teach a simple case on a particular context that's very common. Has to do with two young ladies who started slumberkins. Okay, and these are plush toys with books that are read between parents and younger children to build affirmation and confidence and to talk all about things that aren't being discussed as much as they used to. So they originally got design patents on their plush toys, which was really helpful in the beginning. Because they could send out cease and desist letters to people who were copying them. But then they realized the copyrights on all the stories that were being read that they were writing that complemented the books were quite powerful. And then suddenly, somehow, somebody called to get a license to the copyright because they wanted to make a media story about slumberkins. And it turned out to be Jim Henson. Okay, what's the story there? You can start with one form, but you better think about how the marketplace is experiencing your offering. And if it's something like a media or some kind of story that's being told, copyright is your answer. If it's something that is driving repeat purchase through a mnemonic that is aggregating goodwill like a trademark, then that's your obvious path. So don't focus on one. Do the thing that you can afford. And so I have 4 daughters, right? And they're all athletes. So they're big fans of this product called Spanx. Have we all heard of Spanx? Okay. As soon as I mention Spanx, everyone knows what I'm talking about, right? But this was an unemployed lawyer who actually developed it. That was Sarah Blakely, right? And she went and she did all the patent research, but the genius of, and she figured out how to cross weave so that it actually gave good form in its use. But her genius was coming up with the word Spanx, single syllable, ends in a hard consonant, slightly suggestive of I don't know what, but it sticks. And that's her power, really, being able to produce that product and owning that brand that is still worthwhile for students to hear, even though the patent world isn't working the way it used to.
Yeah. So I wanted to comment, Wayne, you had brought up the challenges facing startups, particularly students at places like Berkeley or Stanford. I worry much less about those students, right? Northern California and Silicon Valley, we have tremendous access compared to most of the country and certainly compared to the world to investors, to angel investors, to incubators, to support, to entrepreneurial clinics that are free. Morrison Foerster runs a cyclical kind of training for startups. It's like an 8-week series, and they focus on different aspects of startup formation and understanding stock and intellectual property. And it just runs all the time, basically. I've sat in on a few of them myself. It's been incredibly powerful. Lots of people who are presumably entrepreneurs or would-be entrepreneurs go to those events. There are myriad resources here, or I should say here, where I'm from in Northern California, to support inventors and startup founders. It's really the rest of the country that I would be much more worried about. Do we have those sorts of educational and supportive resources available, throughout to a diverse audience, in rural areas throughout the country? And that's where I think we have a much bigger challenge.
Well, and this is because I was director for the West Coast USPTO, I can say this. I think this is one of the great, frauds that the USPTO puts out there. They call themselves the innovation agency and push patents as the core to innovation and don't really bring in this whole idea of business. I've long advocated that they need to dissolve the regional offices. They need to get rid of the outreach offices and put them with the Small Business Administration. Somebody should be teaching business first, IP second. But they flip it around. So to me, one of the most dangerous things that I can see out there, and you go play with ChatGPT on this, about the value of patents. And that's the first thing you can do, or you should do. And I saw this at Cooley. So many people show up to their patent lawyer before they show up to their investors and their business people. And I think there's this horrible myth that patents should be first. And whether they're weak or in my opinion, whether they're weak or powerful and how it's changed over time, it's kind of irrelevant. They should have never led first. Should have always been the business model that led first. The IP comes second to put a business model together. And for educational purposes, it seems like that's what we should be teaching. Focus on the business side first. Once you've got a great business idea, then think about how to protect it. But can't be vice versa. Outside of universities where you have professors that are in silos that are just there for research. That's a different model. But for most of us that are just inventing and trying to build a company, it's a different world.
Yeah, I can see how an inexperienced founder might feel, I have to get a patent first, otherwise no one's going to take me seriously. I need to be able to show an actual asset in order to get the support of investors. But I definitely see the risk in that as well. It's maybe more general, just file whatever, see if it sticks. They may be filing too broadly. They may not be limiting their claims the way they ought. They may be filing in the wrong countries or not even really, or over-filing, spending a lot of money early on, not even realizing which company or countries are actually going to be important. So definitely, I feel like it has to go hand in hand. It shouldn't be just IP education, and it should not just be business education.
Part of the issue, I think, is a patent is 100% of something. And that feeling that you own this, assuming the patent's valid and it holds up, it's very powerful. And to see 4 of them on your wall, you think you've done something, but it may be 100% of nothing. In most of the cases, it is, except perhaps in pharma. Yeah.
I like, if you really look around Silicon Valley, it's the corporate lawyers and the business lawyers that run the place, not the IP lawyers. And I think there's a reason for that, because they're the ones actually making the business move forward at those critical junctures. The IP attorneys are providing support in necessary pieces. But if you look at the small companies that have succeeded, that are generating jobs, it's not because they've got a patent, it's because they had a good idea to begin with, and then they could protect themselves afterwards.
Yes.
Hopefully, I guess that's everybody's dream, to be so popular, people start trying to copy you and steal your ideas.
Wayne, we have time for a few questions, and then we can wrap up. Sarah?
Hi, thank you. First of all, I have so much respect for the 3 of you and the creative tension around this question. But my thought is this. As you talk about education, you've all talked very much about the college level and the graduate level and the law school level. But when we're talking about younger children and young adults, undergrads who aren't law school path, or even our high school students, and when I talk to a lot of community college folks these days, and even 4-year institutions, we have to remember we're dealing with a lot of high school students. More and more high school students take college classes, online, in person, and so forth. And they're part of these conversations. And because of AI and a lot of other opportunities online, have opportunities to start their own business and are. What they don't have is the IP acumen to know that their logos, their taglines, their IP is IP. And so when we talk about what comes first, it's kind of the chicken and the egg conversation, honestly. What comes first, the patent or the business? I'm curious because what I'd love to know more about is, if we're talking about the business should come first before the patent potentially, how are we working with people in general to know that their ideas are important and should be protected? To your point, here in the US and in some parts of the US, there's a lot more access than in other parts of the world. Where we're seeing, frankly, I will tell you, especially at the K-12 level, we are seeing a lot of activity around intellectual property and entrepreneurship programs. TIE Global, if some of you are familiar with TIE Global, is a incrementally growing program for young people in the entrepreneurship space coming out of India. And so I'd just love to hear more of that thought process around that conversation that you were just having around patents versus business, and how we're helping young people understand that a patent could be 100% of nothing, but it's also a tangible asset if you have a business.
So, Sarah, thank you very much for the question. This is almost a timeless one. How do we raise, and this is the title of this meeting, the awareness amongst the next generation? How are we doing cleverly? I think that's a heavy lift. What we have to perhaps start sinking in there is the whole idea of ownership, right? You own something. And there are these laws out there that eventually are going to help you capitalize on your creativity. But I have not seen what you do, and I'm ashamed. I need to learn more about that. But I have a hard enough time with the graduate students. Dan has to deal with the undergraduates. And, raising that awareness is a constant thing. And it has to be a refrain at all points of interaction as they develop their business model. But it shouldn't be one where, like you see on some of these shows, do you have a patent? If you don't have a patent, you're not going to get any of my money. No, it shouldn't be that. But that's unfortunately a dominant narrative.
And I would say the greatest learning environment tends to be friends and family, and those ecosystems. And that's the reason you look at what's happening in Silicon Valley. It's because the kid in the desk next to you just launched an app, and you have these discussions not as part of a formal training, but as part of your friend group. And I think that's why you see systems spin up in an area. We looked very hard when I was at the USPTO at where inventions were coming from, and they're in clusters. And I don't think that is a coincidence.
Thank you.
So regarding business coming first or IP coming first, I think that's a bit of a chicken and the egg problem. What really needs to come first is, are you solving a real right now problem? If you are not doing that, the business fails and the IP fails if you're not doing that. I don't know that we can separate them. They have to go together in a parallel process. And it's the development of the IP during the development of the problem-solving process that gives you a very easy pathway to a provisional, which is very inexpensive. You have a year to see if the business works. So I think we should champion the fact of focusing and solving on real right now problems, not the ideas or potentials, and reducing them to practice during the development process so that there is a greater chance of success.
Stole my fire.
Yeah.
I was going to say almost the same thing, except what comes first is the idea. And you have an idea, and sometimes writing it down in a form so that you can understand it and clearly express it to people. I'm not saying an idea for a website, I'm saying a real creative idea, and that becomes a provisional patent, or it doesn't, but it is, the thing that comes first is the idea, not the business or the patent.
So Tony said something earlier about what is going on at Corning that's going to dramatically affect everything going forward. And that is the ability to capture what was tacit knowledge and make it explicit. And it's not going to take any more effort than me speaking into this microphone. And it's going to be, it's already happening with your Microsoft Teams, apparently. You've enabled all that, Tony. And, it's going to happen increasingly. The question is going to, who's going to own all that? Is it going to be a private network, all that? But that is going to make the property discussion that much more present everywhere. And I'm not sure how it's going to unfold. I'm looking forward to learning about what's its role in primary education, secondary education. That I can't even imagine. They are the natives you spoke to, Albie.
I really appreciate you bringing up injunctions. By definition, we're talking about a right to exclude.
Yeah.
That in today's bizarro world can no longer be used to exclude. How did that happen?
Well, it was a Supreme Court case. I'll let the guy from the law school talk about that.
You really want to know? I was there. I was a junior associate on the case for eBay. So it was eBay MercExchange, 2006 Supreme Court case. it changed everything. So for those of you that haven't been steeped in all this, it used to be almost an automatic injunction right. And I mean, you basically a one-page paper and this injunction would come out. That particular case, my supervisor, that lawyer, had a reputation for being very persnickety, downright aggressive and hostile. The battle between the sides was immense. And the district court judge said, there's no way I can give an injunction here without you people being back in front of me fighting about the injunction next week. I don't want to see you again. And he just kind of impulsively said, no, you're not getting an injunction. It's not right. And they wrote it up and based it on traditional factors of equity. And then it percolated up to the Supreme Court. But that's not how anybody originally designed it. And then when it went to the Supreme Court, they said, oh no, this is how it should be. It's always supposed to have these traditional factors. But it was a reaction to what, it got there accidentally, but the Supreme Court's decision, I would say, had a lot to do with the social factors at the time and the explanation about a term that had then grabbed public attention, patent troll. And that set it out, and now no one can change it. Big tech in the valley, fights aggressively to maintain what it is, and now you get these two camps: patent hold up, patent hold out. But this is one of the things that if you look at the rest of the world, the systems that are effective all have that automatic injunction. And the German system, the Unified Patent Court, and the Brazilian system are probably the three most advanced in the world. The Netherlands. And they all have that system, and they scoff at us because we're too expensive and we have no injunction right. So that really does hurt small, medium practicing entities to not have that right anymore.
What do you think this weakness in the system is going to means for innovation? Because it's not just big companies besting smaller entities. That's certainly part of it, but the end of it is the DNA innovation. If innovation is determined or framed by 4 or 5 large companies, that can't be too healthy for to the economy or for innovation.
So I'll just answer that by going back to the whole idea of context. So Wayne knows, and Diane as well, that each industry has its own history, and pharmaceutical IP is one thing, high tech is another, and automobiles another. I think we just have to be really resourceful about how we're going to use these regimes, and you don't have to go any further than the apple counter at the grocery store. You see this Honey Crisp. You see this Cosmic Crisp. You see these branded apples, okay? That is a plant patent, which was new. It was invented in 1930. That controls who can grow the tree. But somehow the genetic material has become part of the utility patent regime. And then separately, the Department of Agriculture has this right. They have an IP right associated with new crops, asexually reproducing plants. It's a totally different thing. So maybe that's what needs to be done. The different departments come up with these different rights. Maybe that's the path through. And we don't wait for the wisdom of the USPTO to somehow percolate up and solve the problem. Right? And in the fruit business, I'm telling you that this is really all sorts of innovation going on there. And it takes a long time to raise a new apple, like 10 years. You got to cut down the whole orchard, grow these trees. And that's a hard sell to the person that has the orchard. But it's working. And in Washington State University, that's a big revenue source.
Better conclude. Last question.
So just to come back to AI, what does all of this, how does this all get impacted by the fact that I can go from idea to product in a few hours? Potentially, if it's a software only development.
So I think the question, sorry, the sound up here, as you pointed out earlier, is tough. You were asking that how does AI impact the fact that product development now is days, weeks, months, rather than years? So the speed of innovation and speed of release is much different. My first take on that is we've seen it in the software industry already. We have a model that if the products can come out faster than the patent system can issue, then the patents really become irrelevant. A great example of this was the telecom lasers. You could put one out, they could be knocked off in about 9 months, and then the next product was out about 9 months later. The patents were incredible technology, but the patents never had any impact. And I think that's my estimate, I'm guessing, like everybody else on this, is that the speed will let people release products, beat the patents, and then move on to the next product before patents really matter. That means that what James was saying is more important. You better have other means of protection and markets or ecosystems or manufacturing contracts. You got to have something else, because patents won't be there for these fast developed products.
To add a final thought on that, it's obviously going to be very industry specific. Certain industries, there's not going to be a brand new product coming every 3 weeks or even every 3 months. Others, of course, that may be a risk. And I do think it's going to put even more pressure on people to file. If you are going to file for a patent, file very quickly. So thank goodness we're on a first to file system now. You have to really rush.
So 30 seconds. Who wants the last 30 seconds? We give it.
Well, these meetings are always so eye-opening because we hear different perspectives about this. And actually, there's a wealth of historical knowledge in this audience, and it's surfacing right here. That maybe the one-size-fits-all patent system that we've had for a long time, isn't really for the future. Maybe we should have a patent for these very quickly developed products that is examined and granted or not granted in a week. Wouldn't that be something? Right? It has the full force and enforceability. If we can imagine it, it's possible. But whether or not we can legislate it is the real difficult question.
I would say you never worked at the USPTO if you think they can do it in a week.
Well, I was on your board.
Thank you, panel. Wayne, James, and Diane.